Thinking about divorce in Indiana? Whether you're just starting to explore your options or already filed papers, understanding the legal process is key. In this video, we'll break down how divorce works in Indiana, from filing to final decree, in under 4 minutes. Divorce in Indiana, a step-by-step legal guide. Step 1. Residency requirements. First things first. To file for divorce in Indiana, either you or your spouse must have lived in the state for at least 6 months, and in the county where you're filing for at least 3 months. If you don't meet this requirement, your case could be dismissed. Step 2. Grounds for divorce. Indiana is a no-fault divorce state, which means you don't have to prove wrongdoing. Most people file on the ground of an irretrievable breakdown of the marriage. There are a few fault-based grounds like felony conviction or impotence, but they're rarely used. The divorce process officially begins when one spouse, called the petitioner, files a petition for dissolution of marriage in the county court. The other spouse, called the respondent, is then served with the divorce papers. Step 4. Waiting period. Indiana has a mandatory 60-day waiting period from the date you file before the court can finalize your divorce. This gives both parties time to work out important issues, or even reconsider. Step 5. Temporary orders. If needed, either spouse can request temporary orders for things like child custody, spousal support, or who stays in the home. These orders last until the final divorce hearing. Step 6. Mediation or arbitration. Mediation is a voluntary and informal process where a neutral third party, called a mediator, helps both spouses work out agreements on issues like property, custody, and support. The mediator doesn't make decisions, they help you reach your own. Arbitration, on the other hand, is more formal. An arbitrator acts like a private judge, listening to both sides and making binding decisions. It's sometimes used when mediation fails or when both parties want a quicker, private alternative to court. Step 7. Contested versus uncontested divorce. If both spouses agree on everything, it's an uncontested divorce, quicker, cheaper, and less stressful. But if you can't agree, it becomes a contested divorce, and a judge will decide the unresolved issues after a hearing or trial. Step 8. Final hearing and decree. Once all issues are resolved, you'll have a final hearing. If everything is in order, the judge will issue a decree of dissolution, officially ending the marriage. Step 9. After the divorce. After the divorce, you may need to update legal documents, divide retirement accounts, or follow through with parenting plans or support payments. The court order is legally binding, so compliance is essential. Divorce can feel overwhelming, but you don't have to go through it alone. Whether you need help with mediation, arbitration, or representation in court, Integrity Law LLC is here to guide you every step of the way. Call us at 317-835-9489 or email us at contactus@integritylawllc.com. Integrity Law LLC, your trusted ally in the legal system.